Good morning and welcome to our Spotlight video series where we talk about cutting edge employment law issues. I'm Tom Spiggle, founder of the Spiggle Law Firm. We help people who have been fired or afraid that they might be. I am thrilled today to be joined by Michael Ludwig, who is a senior attorney in our office. And what are we going to be talking about today, Mike?
Good morning, Tom. We're going to be talking about what's required to have a hostile work environment or a harassment claim. Tom will specifically talk about how courts, when viewing those possible legal claims, they note, we as a firm like to say that courts are not superior HR departments, and that ultimately clients, employees will need what's called either a protected class or a protected action in order to have an actual hostile work environment or harassment claim. Because I think most people, when they think about harassment or hostile work environment, they think, well, if I'm being mistreated, if I'm being even like specifically targeted by my boss, for extra work or for just micromanaging or extra discipline when I don't deserve it. The issue for that is that we need that protected class or protected activity, and a protected class would be as defined in Title VII of the Civil Rights Act of 1964, that would be a protected class based on your race, your sex, your disability, your age, sexual orientation, and then also if you have engaged in a protected activity. So if you have previously reported discrimination based on a protected class, such as age, race, sex, or disability, and then you believe that after that you're being harassed because of that complaint, that would then be a protected activity. So for example, on the other side is if you believe that you're being targeted specifically by your employer, by your supervisor, just because he doesn't like you in particular, or because it's based on a reason that's not a protected class, such as you being a specific fan of a sports team, just for example, that would not be sufficient to have an actual or cognizable hostile work environment or harassment claim. So I find sometimes that's the biggest gap and misunderstanding in which employees or potential clients, when looking at possible harassment, are kind of missing, and it's totally understandable. I mean, that's a very kind of niche thing to know about the employment law, is that for a harassment claim or for a hostile work environment claim, there needs to be those harassing actions that can be severe and pervasive. However, again, they need to be based on a protected class or protected activities. So it's often not enough if you believe you're being treated unfairly, and even if you are being clearly treated unfairly, but if it's not based on a protected class, if you and the supervisor who's taking these actions against you are the same race and the same age and the same gender, and there's no real suggestion that it's based on any of those classes, then we really don't have that harassment claim that we would be looking for when clients come to us about those cases.
Yeah, absolutely. I think it's a great point, and it's understandable that people get confused about this, who are not lawyers, and even lawyers who don't practice employment law get confused about this, because on the one hand, you could be in an environment that's clearly hostile, right? Like, like your boss is coming in, he's kicking chairs, he's, cursing, he's, throwing binder clips, whatever. Like by the Webster's dictionary definition of that, that's a hostile environment that you are in. But the legal definition of that is much more narrow, and it does, as you say, have to be on a protected class. And so, you and I were talking about this a little bit before we started recording. Like, I call it kind of the one protection that employers have, ironically, is I call the equal opportunity asshole rule. So if I'm the boss and I come in and I'm yelling and throwing and kicking, not kicking you, but let's say because that would be illegal. You're kicking chairs, whatever, doing things that are clearly hostile. And I'm doing it to everybody in the room, white, black, brown, man, woman, pregnant, not pregnant. I'm an equal opportunity asshole. Like, that's a Webster's definition of a hostile work environment, but that's not the legal definition, because the bad boss is not coming there and picking on people based on a, as you say, a protected class. Change the facts of that. If I come in and I'm only kicking, yelling, screaming at the women, or I'm only kicking, yelling, screaming at black people, or I'm only kicking and yelling, screaming at people who are pregnant, then that is a hostile work environment based on a protected class. Because we can say, hey, in this room were white people, brown people, black people, Asian people, and you, boss, only did this to the black people. Every time you came in, you only did this to the black people. that's protected class. You want, or white men, like every time you came in, that's a protected class. Like, every time you came in, you only did it to white men, that is actionable. But if this boss is doing it to everybody in the room, it's understandable. People call us and they're like, hey, I'm in a hostile work environment. We're like, we agree, you're in a hostile work environment, but not what we call a legally actionable one, because it's not based on a protected class. I think it's important, the one example that I won't say a workaround about this, but one thing to keep in mind for folks, if you report it, right? If you go to HR and you say, hey, I think I am being harassed based on my race, sex, gender, sexual orientation, any of the number of protected classes, even if you're wrong, right? As long as it's a good faith belief, you came forward, you said this, you believe it to be true, and it's good faith. Even if you're wrong, if there is retaliation taken against you, then that is actionable, even if the underlying conduct is legally not actionable. So anyway, it's very complicated. It's something we see over and over, and I think it's a great point that you raised.
Yeah, no, and just to follow up on what you said about the protected activity, yeah, that is the other kind of section, is if you report, or if you believe and you report that you've been discriminated against based on protected class, such as a race, sex, discrimination, age. And again, so long as it's an honest and good faith belief, it doesn't have to be accurate, but then that will kind of that will add a layer of protection, because then if you feel like your boss is then targeting you, or if he says, hey, you reported me that, I'm pissed off about that, and then takes all these actions against you because of that, that would be retaliation, and that is, an actionable claim. And I know, at least in my experience, it's courts and administrative bodies are just, they're a bit, the reason why, this is how it's set up in Title VII of the Civil Rights Act, and this is how the employment laws are taken. But in most states in the United States, they're at will employment, which means you can be terminated for any reason or no reason at all, so long as it's not unlawful. And so judges and courts are going to kind of look at actions by employers, and if there isn't a protected class, they can say, well, even as you and I, Tom, just talked about, we can say, well, it's clearly a hostile environment. This is not a healthy environment. This is, I wouldn't want to work there. But they're going to hesitate to get involved in like an employer's actions, because they don't want to kind of be as I said before, a superior HR kind of body, or they don't want to get involved and start questioning an employer's decision making or their choices to hire hostile workers or supervisors. Because I've even had like in cases, administrative judges say, yeah, like this boss seems like the horrible guy. I'm surprised that the company keeps employing him. He seems like he's he really is not doing his job. He's not doing his job well. He's being a terrible manager. But if there isn't that protected class or protected activity, then even though a judge is going to say kind of what you, or a administrative body is going to say what you and I are saying of, well, that's a textbook hostile environment, but there isn't an actionable legal claim there. So so the big key there is to say that, well, I'm being targeted because of my protected class, or I've reported discrimination based on a protected class, and now because of that, I'm being retaliated against or punished for that report.
Yeah, absolutely. Well, Mike, I appreciate you taking the time this morning. I think it's a very important topic and one we see over and over, so I hope folks find this useful. I certainly enjoyed talking with you about it.
All right. Thank you, Tom.
All right. Take care.